Welcome everyone to the Genus monthly webinar, Transferring Wealth to Your Children. We will be starting momentarily in 1 minute. Just giving everyone a chance to get in. We have quite a few people today. Very popular webinar topic. All right. Good morning, everyone. Welcome once again to the Genus monthly webinar, Transferring Wealth to Your Children. My name is Ian Lusher. I'm a partner and a portfolio manager at Genus. I'd like to give a warm welcome to Eli Walker, partner from Aaron Gordon Dakin Nordlinger LLP. We've added some links to both Eli and myself in regards to social media and the chat, and I'd encourage you to reach out to us if you have any questions and check out our social media channels, which are very exciting. So today, Eli and I will be going through how to navigate modern family law issues, three common problem areas of transferring wealth to your children and their solutions. So the first one is the gift to buy a home. Secondly, putting your assets into joint tenancy with your child. The family business, family trust, and non-voting shares. At the end, we'll have ample time for Q&A. So please put your questions in the chat. We'll be curating them. While we wait for more people to log in, let's take care of a few housekeeping items. Number one, maximize your screen for best viewing experience. You want to be able to see the slides and see Eli talking. As I mentioned, please type your questions in the chat at any time, and we'll spend our time together answering those questions. If you have any technical troubles, you can let us know through the chat as well. We have someone on hand that will assist you. One great solution just from past experience is if you're having audio trouble or video trouble is to hop off and then come back on again. I'd like to start by extending my gratitude to the Indigenous people, specifically Coast Salish, Tsleil-Waututh, Squamish, and Musqueam, whose lands I'm honored to speak to you today. We do this to reaffirm our commitment and responsibility in improving relationships between nations and our own understanding of local Indigenous peoples and their culture. Canada is home to Indigenous people from across Turtle Island, and we're grateful to have the opportunity to meet and work on this territory. Okay, let's get started. Eli, it's over to you.
Thank you very much. Thank you, Ian. I appreciate that. Before Ian and I got on stage this morning, I'd learned that he's, like me, a Canucks fan. And although hope springs eternal, yesterday the Canucks were mathematically eliminated from the playoffs, even though practically we may have been eliminated long ago. So it's a tough day for all Canucks fans, and I'm grateful for Ian introducing me this morning. Thank you for having me here. Thank you also to all of the attendees this morning and to Genus Capital Management for having me. I'm a divorce lawyer, and as a divorce lawyer, sometimes you get tired of arguing for a living. And it's quite pleasant to spend a morning going and doing something else. And these sorts of presentations are a really lovely opportunity for me to get to do something else, but at the same time, I still get to hear the sound of my own voice. And really, that's what a lawyer wants. And so it's a marvelous opportunity for me. I'm very grateful to be here. And I hope that you'll enjoy yourselves this morning. So as Ian said, today we're here to talk about three common estate planning mechanisms and how those three common estate planning mechanisms may be impacted by my area of expertise, divorce law. And so the idea behind this discussion is that these are three common estate planning steps that you may be considering in your life, or you may have already as part of your estate plan, and they may be impacted in interesting ways by a divorce, God forbid, of one or more of your children. And so these are the scenarios that I want to talk about today, and I want to explain the three problems that can arise in relation to these three common scenarios and talk about some potential solutions. Now, on this slide in front of you now, you've got the three scenarios that we're going to talk about today. And this is my first opportunity to lean on and bring in the assistance of our technical expert, Graham, today, who's behind the scenes. Because of the marvel of technology and also the fringe benefit of the pandemic, where we're doing this presentation remotely and we're all much more comfortable with doing these sorts of things remotely, we're able to ask you, if you would, to participate in a straw poll starting now, so that while I'm talking to you this morning, I can get some live feedback from you over the next couple minutes about which of these three questions is most relevant to you. And so I'm going to try and touch on all three of them, of course, this morning, but we want to leave ample time for questions. And so some guidance from you, the audience, about which of these three questions is most pertinent to you would be lovely. And it allows us to also flex our technological muscle and get to enjoy doing a poll together this morning. And so while you're answering those questions, I want to talk about two statistics as we move into the first area that I'm going to talk about, the gift to buy a home. First, divorce. You may have seen in Stats Canada's clever media blasts after they do their census that the raw rate of divorces and the number of divorces per 1,000 marriages is actually declining in Canada. It's actually going down, which is good news. It's not clear yet to us whether that's because more and more young couples are choosing to run their relationship on a common law basis. So they stay together on a common law basis. When they break up, they still need help from people like me, but their breakup doesn't register as a statistical event that Stats can record. That could be what's going on. It also may be that divorce lawyers like me have made divorce so bloody expensive and unpalatable that less and less people are doing it. And if so, it's a service to society, I suppose, that we've been doing. The second statistic, and this leads to the first topic, the gift to buy a home, is last fall you may have seen news reports about CIBC Capital Markets data set reporting that more and more people are choosing to make cash gifts to children to assist them to buy a first home or their second moving up home. And this phenomenon, not surprisingly, is most prevalent in Vancouver and Toronto, where the real estate prices have been out of control. Those statistics have been, in Vancouver, it's about a 25% mark of first-time buyers are getting financial assistance from parents in order to purchase their first home. And about 5% of mover-uppers are getting assistance from parents to buy their second home, their moving up home. The average size of those cash gifts has been $180,000 to $340,000 in the data set sampled by CIBC. And we are seeing that anecdotally in divorce law as well. As the market in Vancouver has exploded and cash gifting to assist children to buy homes has increased, this has become a more and more prevalent problem in our dockets as we see more cases where this fact pattern presents a problem. So that's the first topic that I'm going to talk about. So the gift to buy a home, what's the problem? As I introduce this problem, this is a chance for me to give you a crash course in how does division of property work in British Columbia, so as to give you some context against which how to understand these problems. Here's the crash course. There are three basic rules. The first is when you break up, all assets are divided presumptively 50-50. The second rule and the third rule are that from that presumption, each spouse then gets a chance to argue that certain things should be taken out of that presumptive 50-50 division. The first one, rule 2, is that you get to keep what you brought in. And so if you're able to establish that you own this particular asset at the date of the marriage or the date that you became a common law couple, and what the value of that asset was at that time, you can pull that off the table and keep it out of the 50-50 division. Now, why do you have to establish the value? It's because the law only gives you the exclusion for the value of the asset at the time of the marriage or the cohabitation when you brought it in. It doesn't, the growth in value gets shared 50-50. Okay. Rule 3 is that you also get to keep a gift or inheritance that you receive during the relationship. And so again, if you can establish what the gift or inheritance was and what its value was when it was received and how much, you technically get to keep that off the table. All right. And so that's the basic rule. That's the crash course in division of property. And so why should this be a problem? One would think that if those are the rules, the gift to your child, a cash gift to your child to assist them to purchase a family home for their growing family, would fall under that third rule, and that they would get to keep the value of that cash gift in the unhappy event that they break up. What's happened is that since the law that sets this out was introduced in 2013, our courts have interpreted the law to mean that if a child receives a gift or inheritance like that, and then subsequently makes the decision to transfer that gift into a jointly titled asset, most commonly the family home held in joint tenancy, but it could also be a joint investment account. But most commonly, and here we're talking about the transfer of that cash gift into a family home held in joint tenancy, our case law, our judge-made law, has interpreted the legislation to mean that your child is intending to give that gift away to their spouse when they do that action, when they take that step. And so because the most common fact pattern here is that a parent will choose to make a cash gift like that at the moment of purchase, and so the very transaction results in the gift being lost. The gift of cash is made at the time of closing or at the time of down payment, and it's taken by your child and it's immediately put into joint tenancy in the family home. And according to our law, as it's currently being interpreted, the gift is lost. That's the problem. Okay. Now, I'm going to hasten to add that because there may be judges of the Supreme Court of British Columbia in the audience today, it's not clear whose fault this is, this, in my view, impractical interpretation of the law. It's this interpretation is technically and legally correct. There's nothing legally wrong with it. It's just a lacune in the legislation that's been exploited by highly paid divorce lawyers and endorsed by judges of our Supreme Court to interpret the legislation in this way that is counterintuitive to its plain reading. But that's where we are. And so how can we fix this? And here I'm going to turn to my first slide where I'm going to talk about solutions to these problems that arise in the intersection of your child's divorce and estate planning issues. And in each of these solution slides, what I've tried to do in my own mind, and hopefully that I'll communicate successfully to you, is talk about these solutions in a simplest to most complex order. And so at the top, we're talking about the most straightforward and cheapest solution in terms of cost of transactions and emotional cost in getting it done. And at the bottom is the most expensive in terms of fees and emotional cost in getting it done. And that's the prenuptial agreement. That's the family law solution to these. But this is not, and my presentation today is not an advertisement for prenuptial agreements. It's a comment on when prenuptial agreements can be successfully deployed and when they can't. And so there are some circumstances where there are less interventionist approaches that can work. So let's talk about that in relation to the gift to buy a home. The first potential solution here is to make the cash gift a loan instead of a gift. That is, you would paper the transfer of cash by a promissory note or by an agreement, setting out terms of repayment and an interest rate. It could be that those terms of repayment aren't until one or the other of you or your spouse pass, so that the repayment actually comes out of your child's entitlement to an inheritance. It could be that the interest accrues but isn't payable until the note is due, but paper it. There'd be some kind of promissory note or agreement that papers this as a loan instead of a gift, which keeps it out of the reach of this interpretation of the law. You might also take a mortgage. This most likely would be a second mortgage against title, second to the first conventional lender, RBC, or whoever that may be, who will no doubt require that you be a second lender, not a first lender. But if that's possible, and the lender will accept that, these sorts of papering of the transaction as a loan instead of a gift make it incontrovertible that in the unhappy event that your child were to later break up, there's no dispute that that equity in the property is called for by the loan that you've made rather than lost by a gift to your child that's then conveyed into joint tenancy. Now, there's one significant problem with this idea. Well, there's two. One is, of course, that's emotionally uncomfortable. It takes away the idea of gifting to your child and turns it into a more commercial transaction, and that's unfortunate, but that's what the law is telling us to do right now. The second is that commonly lenders are going to require you, if you are providing cash to your child to assist them to purchase their first home, they're going to require you to complete a gift letter, meaning they want comfort that if the money for the down payment or to close on the purchase is coming from somebody other than the purchaser, your child, that it's not going to throw their debt to equity ratios and their debt servicing ratios that they've done for your child's ability to meet the mortgage they have with the bank. It's not going to throw those out of whack. And if they find out that, in fact, the money coming from mom and dad is a loan and not a gift, they may not lend. And so that may scupper this in some scenarios as a solution to this problem. Okay. And so what's solution two? Solution two is you can make it an investment instead of a gift. You can go on title with your child. Again, emotionally, that may not be as comfortable, and it may take some of the notion of the gift to your child out of the equation, and that's unfortunate, but it's a solution to this issue. If you're on title and your child is on title and the spouse is not, there's again no ambiguity about what that equity represents in the unhappy event that your child breaks up. I should add to this, and I should have put it in the slide, the third option here, but it's one over which you would lose some control, is that you can insist that if you're going to make a gift to your child in order to assist them in the purchase of a home, that the title would be in their sole name. Rather, there would be no joint tenancy on title. Now, you can't control what your child subsequently may do with title, and so if at a certain point they decide to transfer title into joint tenancy, making the decision to gift away the exclusion they came in with in the shape of your gift, so be it. But at least out of the gate, you're protecting the investment in that way. The last, the prenuptial agreement. This would be a family law agreement done by family lawyers to specifically carve out the gift, no matter what subsequent transactions the child might enter into. Now, let's move on to talk about the next problem and solution. But before I do that, I wonder if Graham might assist me to see what the results of that first poll are. I'm having trouble finding out from him. So let's carry on talking and I'll report the results of that as soon as I can. Here's our second problem that we're going to talk about. Transfer of your assets into joint tenancy with your child. This is typically a step that's taken later in life where perhaps one spouse or the other has passed away. The children are financially independent adults, but for both estate planning and administrative reasons, it makes sense to transfer your home into joint tenancy with your child or to transfer an investment account, for instance, into joint tenancy with your child. That can assist in terms of management of the asset, and it also allows you to pass that asset to your child outside of probate. It passes directly to the child by registration of joint tenancy and doesn't have to go through the complex and somewhat expensive process of probating through the Supreme Court of British Columbia. And so this is another common part of many people's estate plan. And the problem is, as you might imagine, is that if your child goes through a divorce or a breakup during a period where they are registered as a joint tenant on an asset of yours, inevitably their spouse is going to claim that at the time of the transfer of the asset into the joint name, it was you were intending to give value to your child, to really make them a half owner of the house on the moment you transferred title to them, rather than it being an administrative measure that was intended to only represent a transfer of value once you actually pass away. Now here, there is some relief in the law, and instead of it being a negative in terms of how the law interprets that. And that's the first, it's not really a solution, it's something I want to flag for you. That's a protection that's already available to you in relation to this estate planning mechanism. Here, our judge-made law will, absent other evidence to the contrary, it will interpret that transfer most likely to mean that you did not intend to give away the value. If you were transferring title to your home into joint tenancy with your adult child who's financially independent, it will first assume that that was intended to be an estate planning measure and that you continued to retain all the value of the house, even though you transferred half the title to your child. That's not a bulletproof defense in all cases, but at least the trend line on how the law will interpret that is more favorable than it is in relation to the cash gift. The second, similar to the idea of either coming on title or making a loan instead of a gift, is papering your intentions at the time of the transfer. And so both where judges will assume that your child intends to give away a cash gift when they're purchasing a house in joint tenancy, and where a judge will assume that you did not intend to give away title to your house when you put it into joint tenancy with your adult independent child. These are what are called evidentiary presumptions, where a judge is going to draw a conclusion based on the law telling them they can make these evidentiary presumptions where there is an absence of real contemporaneous evidence at the time of the transfer. Now, this isn't uncommon. A lot of these transactions occur with a minimum of corollary paperwork around them explaining why the transactions are being done at the time, which creates the opportunity years later, if there's a dispute that results in a financial benefit to one party or the other, if there's a dispute about what the intentions were for that transaction, there's going to be a dispute about it in the absence of specific papered intentions. And so if, for instance, you are making a choice to transfer your title of your house into joint tenancy to your adult independent child, you can paper it at the time by a letter of intention that might be addressed to the executor of your will, or perhaps to the lawyer executing the transfer, or perhaps to your child and their spouse, that specifically states that the intention of the transfer is not to give away the beneficial interest in the property, the real value of the property, but rather as an estate planning measure, as an administrative convenience. All right. And then last, of course, again, as the full-throated solution to this is the prenuptial agreement. Let's talk about problem number 3 that we want to touch on this morning. This might be a bit more of an esoteric one. I know that this may not apply to everybody in the audience, but I did want to touch on it in case there are questions that may arise about it during our question and answer discussion after I finish my presentation. This is the family business succession planning. The common estate plan to transfer the value of the family business to the next generation in British Columbia is by way of what's called an estate freeze. And an estate freeze, in basic terms, is a transaction where you and your spouse will at a certain point decide that you've derived enough value from the family business, and through a corporate transaction, you'll freeze the value of that family business, and you'll keep, in a new series of shares, you'll keep the value of the family business up to that point. And then the future growth in the family business, any future upside in the family business, will go to a new class of shares that will be issued either directly to your children or to a trust of which they are beneficiaries. Now, those shares typically, those new shares, growth shares, typically won't carry votes. And so what this allows you to do is for you to keep the value you've accumulated to that point in the business, to pass on the future growth in value to your children, in a tax effective way, and in a way that still allows you to retain voting control until you pass. And this is a very common solution to family business planning in British Columbia. The problem that it creates from a family law perspective is that the interest in that trust holding those growth shares or those non-voting shares themselves, if they're passed directly to the children, family law will sometimes interpret those to have value, even though they have no fair market value at all. What do I mean by that? I mean that it's plain that a non-voting series of shares like this, or an interest in a trust like this, that you might vest in your children as part of your estate plan for family business, it's plain that your children can't go sell that in the open market. No one would buy it. But will a family law court necessarily conclude that they have no value because of that? Potentially not. And so the most pernicious worst case scenario that can arise here is where your child is put in a position because of your estate plan where they have to give up a stake in real, tangible, exigible, fungible assets like the family home in order to buy their spouse out of ephemeral value in these non-voting shares or interest and trust that they really can't access without your permission or help or upon your passing. And so this is a more complex problem, and there are less solutions to it. Number one, I would say if it's something that you're having to deal with, you want to deal with it by way of a trust rather than immediate disposition of non-voting shares to the children. And number two, this is certainly an area where a prenuptial agreement is almost always going to be a sensible solution to consider. So before I move along now to make a few comments about prenuptial agreements and when they appropriately mesh with these three potential problems, let me say that we're trying to reserve plenty of time for questions and discussion after this. And so I'm on target to make a few comments now about prenuptial agreements, and then hopefully I'll wrap up out about the half an hour mark so that you'll have some time to ask me some questions if you like, and we'll get some results on our poll, hopefully. Now, if Graham is available, perhaps this might be a time where, even though we haven't canvassed the results of our first poll yet, we might ask him to tell us or invite us to vote on the second poll that we have in mind today. And that's to know whether or not, regarding the first topic, the cash gift to buy a home, I'm curious to hear from the audience about this. Is this something that you are considering? Number two, that you've already done? Or number three, no, having heard me today, you've concluded you're not going to do that. And I'd be interested to hear from the audience on that. And hopefully Graham's got us set up to answer those poll questions. And I see that that's en route. That's great. All right. While you're answering that, let me talk a little bit about prenuptial agreements. What are they and what are they good for and what are they not good for? First of all, prenuptial agreements, they are binding contracts like a commercial contract between Coca-Cola and a bottling company. In that sense, they're intended to be binding. They're subject to the same rules of variation as commercial contracts are. And in that sense, they are binding. There is, however, a specific piece of one section of our family law legislation that allows family law judges hearing family law cases to vary prenuptial agreements on a slightly relaxed threshold from commercial contracts. The case law governing that application of that legislation is now about 18 years old. And we recently canvassed the decisions since that leading case about 18 years ago. And the results of that survey were that, typically speaking, after about 5 to 10 years of marriage, every prenuptial agreement does get challenged in the divorce. Meaning that even if you have a prenuptial agreement, even if your child has a prenuptial agreement, after they've been together for about 5 or 10 years, you should expect that the agreement will be at least challenged in the negotiation. And the aggrieved spouse will present some argument as to why it should not be enforced. Does that mean that prenuptial agreements don't have value? It doesn't. They still serve to set the expectations and to set the table differently at the commencement of negotiation than it would be if we were starting from the presumptive 50-50 starting point. And so in our view, there is still considerable value in prenuptial agreements, despite the fact that they are commonly challenged after 5 to 10 years. Second, and this is interesting, only one agreement has been blanket enforced in British Columbia in the last 18 years in a longer than 15-year marriage. After 15 years, they are, except for one case, inevitably varied to some degree or another. And so what's the lesson from that last statistic? The lesson from that last statistic is that in order to make a prenuptial agreement as reliable as possible, you want to be as conservative as possible in a prenuptial agreement. What do I mean by conservative? I mean, make the goals only those goals that are most important to you and your child. Don't make the goals, don't overreach. The more conservative and narrow the scope of the prenuptial agreement, the more likely it is to be enforceable. A sensible prenuptial agreement is a conservative prenuptial agreement. This is my last slide, and then I'll stop enjoying the sound of my own voice, and we'll see what our polls say and what kind of questions we might have from the audience. So what do I mean by that? Protect what matters. If the goal of the agreement is to protect the cash gift to buy a home, then focus on that and don't allow the prenuptial agreement to become muddied with claims to exclude liability for child support or claims to exclude liability for spousal support. Leave those things to the ordinary operation of the law in the unhappy event of a divorce, but protect just what matters. Protect what matters and forget the rest. That's the slogan I've got here at the bottom of my slide. All right. I've covered off the things that I wanted to say. I want to turn it over to the Q&A, but first, perhaps we might canvass the poll results. And I'm not sure if I'll need Ian's help to do that. I do have answers on our second poll, and so why don't we talk about that first. This is the results of our second poll, in which we asked you to tell us about the cash gift to buy a home. Do you intend to do so? Have you already done so? Or no, you don't intend to? And of 105 answers, that's 73% of you responded. Thank you very much for doing so. 40% of you said that yes, you have already made a cash gift to assist in the purchase of a home. 34% of you said that you were considering doing so. And 26% of the respondents said that they don't plan to. I wonder what that number would have been before I started my talk. We should have done it that way. Graham or Ian, could you assist us to have a look at what the first poll result was?
Yeah, it was posted earlier.
Oh, great. I just missed it. I'm sorry.
Yeah. No, it comes in like real time. But essentially, the first two topics are the most popular, particularly the joint adding your name to title or adding a child's name to title seems to be the most popular, along with the gifting. And when I look at the questions that are being asked, we're getting a lot of questions on these different types of topics. So I thank everyone for the questions. Much appreciated. Very thoughtful questions. I'm going to go through most of the questions that are not tax related. Eli's a lawyer. I don't know if you're really going to want to answer a lot of in-depth tax questions. So I'm going to try to do the questions first that are related to your presentation and to your expertise, if that's fair.
It is. And Ian, if we have time and you want to run some of the tax questions past me, I'll say plenty of cover my behind things, and I'm happy to engage in that.
That's excellent. Perfect. So first question, it's actually from two different people who were essentially asking the same question, is in regards to giving a gift for the purchase of a home and the way it's being interpreted in BC. Is BC an anomaly? We also had another question that's saying that, you know, the viewer lives in Quebec, and is this the same case in Quebec? So I'm guessing what they're getting to is the law being interpreted across the board in Canada, or is this just a BC specific thing?
That's a great question. And so first of all, I'll say out of the gate that Quebec, I won't be able to comment upon at all, unfortunately, although I could educate myself. But Quebec operates under a civil code that is different in the way it's interpreted than the other common law provinces who derive the manner of interpreting their legislation from the English common law. And so I would be well out of my depth commenting on what's going on in Quebec. In regards to the other common law provinces, Alberta and Manitoba are two interesting examples. Manitoba is experiencing the same problem we are the last time I checked. Alberta has specifically addressed it to correct the issue so that the gift is not lost if contributed to joint tenancy, and that's the way I think it should be. Ontario operates on a rather than a tracing model, where the idea is the problem arises in BC in part because of the lacuna in the legislation, but also because what we have here is called a tracing model, where you only get to keep your exclusions if you can establish where that value has gone over the course of the relationship. And so where the problem arises in BC is in the exercise of tracing. You say, okay, I got a cash gift from my parents on this day, and I put it in the house on this day, and now we own the house here today at the date of our divorce. I've traced it. Now it's mine to keep. And it's in that exercise where the judge-made law has caused us to lose the exclusion. In Ontario, what they do is what's called a comparative net worth model, and they total up your assets at day one, and they total up your assets at the present day, and they deduct your assets at day one from the present day, and you divide the residue. And they're less concerned about tracing, which I like that more mathematical model. It eliminates a lot of, in my view, difficult evidence about tracing, but that allows them to avoid that problem because they simply price in the inheritance as a mathematical item and they don't care where it got spent. I don't know what the answer is in Saskatchewan or the Maritime provinces, and I would have to look it up. Or I would have to get an associate here at my firm to help me look it up. And so that might be one that I'll footnote here for follow-up. Thank you very much for that question.
Okay, thanks, Eli. We have a couple other questions that relate to a similar issue, and I know there was a famous case in BC about this, so I'm sure you'll have lots to say about this, but doesn't putting assets in joint tenancy with the child as an estate planning measure make those assets subject to claims by the child's creditors? So essentially, we're getting a lot of questions on, you put a child on title for estate purposes and something happens and they go bankrupt, or a business, something happens and creditors come after that person.
Yes, that's possible.
Yes. And so can you speak a little bit to that about any cases that have happened that are noteworthy about this, or is this a common issue, or is this just a very rare instance?
No, it does happen. And so the leading case on this is a Supreme Court of Canada case from, I think, 2007 called Picor, which isn't a case that came up from British Columbia, but the law would apply here as well. And that is the case that reaffirmed this idea that in the absence of evidence to the contrary, the law is going to assume that if you're transferring title to an asset into joint names with your financially independent adult child, that you're not intending to give away the value of that asset to the child at the time of the transfer, that it's held on a presumption of resulting trust. Your child is assumed to hold the value of that asset in trust for you. In Picor, the issue arose because of the intervening bankruptcy of the child, I believe. And so in that case, it was a successful defense. But do you want to have to go through that process? No, that's a very fair question. And you're right that to a creditor from a presumptive external point of view, a creditor is going to assume that that asset is exigible in your child's hands, and you can create a mess if there's a risk of an insolvency or bankruptcy on your child's part. That's a very good question. Okay,
another interesting question. Do you think it's better to loan your child a loan to purchase a house, or to loan to both the child and the spouse, with the spouse signing a promissory note?
I think ideally, if both are achievable, then yes, ideally you would make the loan to both children. That would both improve the paper record in the unhappy event of a later divorce. They couldn't deny that they had no knowledge of the advance. And it would also, if it's possible, help from an emotional point of view of everybody feeling like they're on the same page from the outset, and everybody feeling like they're involved in the discussion from the outset. Now, you're right to ask that question in the sense that one of the advantages of doing a loan or making it an investment between you and your child as opposed to a prenuptial agreement is, of course, that it doesn't require the cooperation of your child's spouse. And so if you've got a scenario where they're single, for one, and you don't know what's going to happen in the future, or number two, it's not going to be emotionally possible to negotiate this sort of joint loan or prenuptial agreement with the child's spouse, then that's where making the decision unilaterally between you and your child can be simpler. But ideally, if it's possible emotionally to sell that to your child and their spouse, then I agree it would be preferable to have the loan be to both of them. Thank you for that question.
Okay. Wow, lots of questions here. I'm just going through them all. So bear with me. If I haven't said yours yet, I'm just trying to put it in a nice order here. I've got an interesting question here that I think you will have an interesting answer. What would you think of a child owning a share in the home equal to the gift amount in their sole name, and then the balance being in joint tenancy with a spouse? So if the example is 25% of the home's value or the ownership is in single name because of a gift, and then the 75% of the home is in joint name with the spouse. Is that doable?
That's a really clever thought. I'm being quiet because I've never thought of that. I'm not a real estate conveyancer, and so I don't see why. What might have to happen is that your child might have to hold the asset as a tenant in common with their spouse, as opposed to in joint tenancy, which is a more common arrangement. But the only difference, material difference, is that when one party passes in a joint tenancy, the title passes outside of the estate, and it's simpler and more convenient. It's the same reason that motivates you to put title to your house in your child's joint tenant name as you approach passing. But as a tenant common for a young family, that would allow you to hold them in different proportions, one proportion related to the gift and the other proportion that they share with their spouse, that could be a very clever solution. I haven't seen that. I think that's a really clever question, and whoever's question that is should guard that idea carefully and try and sell it to the real estate conveyancing bar.
Unfortunately, she put it on a public chat, so I don't know about that. Okay, I've got another really interesting question here. At some point later on in life, is there an advantage to transferring sole ownership, sole title to your adult child?
No, I don't think so. I think that would probably be quite uncomfortable for most people who've worked their lives to accumulate that value. And the only scenario where I could see that making sense, let's assume it's the house you're still living in, number one, or an investment account that you're continuing to rely on for returns. The only incentive to do a complete gifting away of the asset to your child during your lifetime, an entire gifting away, I suppose would be for creditor protection purposes. And if you were going to do so, you would need to be prepared to really give it away. Otherwise, the creditor would argue it's a fraudulent conveyance. And so you need to be truly disposing of it to your child, which would, put you in a potentially financially vulnerable position. And so I think it would be preferable when considering the ease of estate administration for your child in the event of your passing, to do the joint tenancy thing instead of the complete transfer.
Okay. Got another good question, and I just flipped to another one, and now I gotta find it again. So one of the questions: do these comments that you've done, do they apply equally to pre-common law situations?
They do, in the sense that some of these problems may arise in a hypothetical sense rather than a real sense. You may be considering making a cash gift to a child who is single or who is dating, and who is, of course, like most of us do, inevitably going to partner up and start a family at some point, but hasn't done so yet. And you've got an eye to considering, well, how do I know that I can ensure that they are going to benefit from that gift and not their future partner? Now, how the law, of course, is going to look at that is that it's not so much a gift or inheritance that's being traced. It's an increase to your child's net worth at the commencement of their relationship, because when the relationship starts, the gift has already been made some years prior. And what you've done is you've essentially beefed up your child's net worth at the time they're entering into this future hypothetical relationship. And so your concern would be, okay, well, I know they start with that value, but let's say they've owned a home in their sole name for years that I helped them purchase, and then they get into a marriage, and then 3 years into the marriage, they sell that place and they go buy a new place together in joint tenancy. The same problem arises. They've lost the exclusion that they had when they brought in their title in sole names. And so the same solutions, potential solutions apply to that, even in that hypothetical scenario. If it's, for instance, a prenuptial agreement, obviously you can't have them sign a prenuptial agreement when the identity of their former spouse is hypothetical. But you might make your child aware that, look, I'm making this cash gift to you now. That's great. if in the event in the future you do partner up, my expectation is that you'll ask that person to sign some agreement recognizing the value of your inheritance that you've received as a gift already. The transfer into joint tenancy, my guess is, because that's typically a later in life decision, is that most of you, if you're considering a transfer into joint tenancy, your children are going to be older and they're more likely to be partnered up, and that's more likely to be a problem that arises midstream in a marriage rather than one that arises before the start of a marriage.
Yeah. Okay, I have a really interesting question. This is the one that I was looking at before. They're all good, but this one is quite interesting. I get this sometimes. What is the risk of establishing a joint tenancy with one of your children and not another? So it could be there, 2 children or 3 children, but you decide to do it with one. And we actually get this quite often where people want to do this with one specific child over others.
Yes, yeah. So here's my first cover my behind moment. I'm a divorce lawyer, not an estate litigation lawyer, but there are similarities. The two do overlap. And I read cases about estate litigation sometimes, and I'm a risk taker, so I'm prepared to comment on this, even though it's not my area of expertise. That is a risk, and there are a series of cases out there in British Columbia where either during the parent's lifetime or after the parent passes, the siblings will get into a litigation contest about whether or not that transfer was intended to convey value to that one child at that time or not. Were they receiving an advance on their inheritance that they now get to keep? Or were they intended to be a steward of that value that then gets divided equally as between them and their other sibling? What will the law say about it? The law is going to assume that the value belongs to either the child it was gifted to or you. There's no scenario where the law is going to say that value is intended for the child who isn't receiving part of the transfer. Now, in a wills variation action, a court would have jurisdiction to adjust your will if necessary, to remedy any unfairness that they found in that. But certainly they're not going to find, absent some other documents, and I'll talk about that in a moment, they're not going to find that your one child holds the value and trust for your other child. Okay, and so that can create problems, and it's something to be alive to. So how can we deal with that? The statement of intentions can address that as well. That can be an important assistance in that transaction. Your will, for instance, might provide for the division of the residue of your estate equally. And if you're transferring an asset outside of your will, like title to your home, to one child and not to both of them, you would definitely, if the intention is for the one child to then share that benefit equally with the other child upon your passing, you would definitely want to paper that by some letter of intention to the executor of your estate or to both children or to such other appropriate addressee of that note. That's a great question.
Okay, so here's, I'm getting tons of questions on capital gains and all these types of things. So you said
let's try.
Yeah, you will give it a whirl. So I'll give you a couple scenarios, but the first one is transfer to joint tenancy. Would the children added to joint tenancy have to pay capital gains of the parents' home when they sell it, as all children own their own principal homes? Would this be more expensive than going through probate? We're also getting questions like, if you gift a condo to a child, does the giftee have to pay capital gains on that? Every situation is different, so some of these questions are pretty hard to answer, but yes.
No, I think those are good. Why don't I do on this one to cover my behind this one? Let me take that and respond to Ian following the presentation, because I think that that's an important question, and I would like it to be answered for you. But I don't want to hazard. I have a guess as to this, but I don't want to hazard it and be wrong. And so I think there are 3 scenarios that I can go get an answer for you on these. One is, does the child who takes joint tenancy to your home carry a capital gains burden because they can't use their principal residence exemption because they already have a principal residence? The second is, let's say you transfer an investment property that already has pregnant capital gains on it to your child as part of your estate plan, do you pay capital gains on that transfer? Well, I guess those would be the two scenarios that are being asked about. Do I have that right, Ian?
Yeah, that's correct. I mean,
Yeah.
it's literally anything to do with, are there capital gains considerations when you do these types of maneuvers?
Yes.
Essentially, in either gifting, there's people asking about seasonal properties, people asking about their own, just this joint tenancy idea. So a lot of questions on tax relating to these types of maneuvers.
Yes, and I think so. I think that this is something that I should come back on. I'll tell you what I think the short answer is, but we'll go confirm this. The principal residence transfer will remain tax exempt. If you were to transfer a property with pregnant capital gains to your financially independent adult child as part of an overall estate plan, like a deemed disposition on death, there's going to be capital gains tax arising on that. That's my guess to those two questions, but we're going to go confirm that and get back to everybody.
Perfect. So everybody who's asking questions or hasn't had their question answered live, we will try to answer them the best we can afterwards and get back to you, so we don't kind of forget about them. We're just trying to get to as many as we can in the time that we have allotted. We have a couple questions on if using living trusts or family trusts is of any use to what you're talking about in terms of gifting. They're kind of like very broad questions, but
yes.
Like what about using family trusts?
Yes. Yeah. So I don't want the tail to wag the dog here. There can still be, as you may have heard, in 2018, the federal government changed the rules regarding dividend sprinkling. And so this family trust question that I've been asked, what it's about is a trust that's not necessarily related to business succession planning, the trust that I talked about where the trust would receive the non-voting growth shares in the family business. A family trust is a more general concept that could hold shares like that, but it could also hold something else. It could hold equity shares in a long-standing company that includes historically accumulated value. It could hold real estate. It could hold an investment account. And in the old days, a family trust would allow you to mitigate tax on the profit earned by the investments held in that trust by sprinkling the income produced by those investments amongst more taxpayers, and called dividend sprinkling. And so some could be distributed to you, some to your spouse, some to your children. That is now gone. And so the dividend sprinkling benefit to a family trust is gone. The estate planning benefit of a family trust may still be there, in the sense that it's a way for you to transfer assets without triggering a capital gain into a trust, and to then have the gain kicked down the road to your children to deal with in due course by distribution through the trust. Will it also operate as a defense to these sorts of family law issues? Probably not. Probably not. And so this is a relatively complex question that here's where it overlaps with the issue I raised about fair market value versus value to your child in a business succession planning context. Those beneficial interests in that family trust that you create to hold, let's say, a recreational property, while they have no fair market value, there's no guarantee that the family law court will see it the same way. And so what kind of things is a court going to be looking at in determining whether an interest in a trust needs to be priced in somehow to a divorce or not? They're going to be looking at the nature of the asset, the use pattern of the asset over time, the contribution of the child to any equity in the asset held by the trust, who the identity of the trustee or trustees are, who the other beneficiaries in the class are, the age of the different participants, in the sense that, how proximate is a distribution from that trust to the benefit of your child, how proximate is a crystallization of that interest. And so although there may still be very good estate planning reasons to establish a family trust for certain people. I don't want you to count on it as a suitable family law remedy. Now, does that mean that you ought not do it? No, it just means that divorce shouldn't drive it.
Right. Okay, last question. We have about 2 minutes for question and answer here, so we'll make this the last question. I've had a few questions on this. Is there a limit to how much money can be gifted to a child, presumably for the purchase of a home, within 1 year with no tax implications?
There is not. And so if you are in a position, for instance, to gift to your child in a manner sufficient that they don't need a conventional mortgage at all, then that would be a very good scenario for you to take a mortgage, because you won't run into that problem of needing to combine your financing with the conventional lender's financing, where the conventional lender requires a gift letter. And so if you're in a position to make that kind of gift, that's a really good scenario to take a mortgage.
Great. Well, thanks very much, Eli, for all your answers, for a great presentation. That's all the time we have for today. For those of you who did not get your question answered, we will provide that. Our team will send answers to your questions to make sure that you have a clear indication of, what Eli would have said if I would have been able to feed the question to him. I want to thank Eli very much for taking the time to speak with us today and express gratitude to both our valued clients and those who are new to Genus. We've made a donation on behalf of the UVic Law Center in the name of Eli to thank him for all his efforts for today and his great presentation. To those of you who are wondering or want to share this, a recording of today's webinar will be provided to you by email and will also appear on our website in the next few days. If you want to revisit it, feel free to share it to friends and family. We'd like you, we'll also send any link to any resources mentioned. Perhaps that may be some of the questions that have not been answered to you directly. Next month, we continue our webinar on May 26th, a webinar series with our own portfolio manager and partner, Grant Conroy, and family enterprise advisor, Cindy Radu, who specializes in helping individuals, family enterprise, business owners, and family offices navigate the complexities and opportunities that come with wealth. Cindy is an amazing speaker. I think you'll really enjoy this topic as much as you've enjoyed today, and I really encourage you to attend the webinar entitled Stop Frankensteining It. Great title. Lastly, please stick around for a few more seconds as we close this session. You'll be redirected to a survey. We really value your input and your thoughts and your feedback to make these webinars better. Thank you very much for taking time to be with us today, and enjoy the rest of your day. Thank you.